And Mr. Trish, you're ready with Mr. Ray's case.
I am. He is in FDOs.
Okay. Sir, there at the Department of Corrections, can you tell me your name, please?
Christopher Ray.
All right, we're on the record in People versus Christopher Ray, case number 246702. The record should reflect that Mr. Ray is present today by video from Department of Corrections. And this is the date and time set for sentencing. Mr. Can I counsel for appearances?
Thank you, Your Honor. Richard Trish appearing on behalf of Mr. Ray.
All right, Mr. Trish, did you have a chance to go through the pre-sentence report with Mr. Ray?
So, Your Honor, I was able to send him an email via JPay that explained to him what the recommendations were. We sent a copy of the PSI to the facility, but admittedly, I don't know that got to him yet.
Okay, do you want to make those inquiries?
Well, I know he received the email because he responded back.
Okay.
Have you got a copy of the PSI yet, Mr. Ray?
No, sir.
Okay, so Mr. Trush, how do you want to have this reset for a time when Mr. Ray's had a chance to review that?
So, I mean, I'm hesitant to do that since effectively he's on dead time right now.
Okay.
The recommendation here, I think, is reasonable and meets the criteria that we were looking for. So I don't have an objection to proceeding forward. Mr. Ray, you understand what the judge is asking you?
Yes, sir.
Okay, so if we were to delay it so that you receive the copy of that PSI we sent, you would come back in about 30 days, but you're not going to get credit for the time between there because you're under sentence already. So we've talked about that issue before. Do you want to proceed forward today, understanding what that recommendation is, or do you want to have an opportunity to go through that PSI?
We can proceed forward.
Okay. All right. Mr. Trush, are there any additions, deletions, or corrections that need to be made to that report?
There are not, Your Honor.
And are there any challenges to the scoring of the guidelines?
There are not, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor, thank you.
And do people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
Judge, in this particular case, we're talking about a delivery of 50 grams, in this case, apparently 11.3 grams of methamphetamine. And I understand 11.3 doesn't sound that much, but as the court's well aware, in regards to methamphetamine, that's a significant amount, as well as hydrocodone. There's a recommendation of 3 years and 4 months to 30 years with 180 days credit. This is defendant's 13th felony. He had 6 outstanding warrants at the time of the offense, including many weapons offenses and 6 prior controlled substance offenses. And one current one, most recently involving methamphetamine in Iron County, as we believe the recommendation is appropriate. We'd ask the court to follow the same.
Thank you, Mr. Trush. Anything on behalf of Mr. Ray?
Yes, Your Honor. It would just indicate, what the prosecutor said is accurate in regards to Mr. Ray had several things going on at the same time. This is just kind of the last one in line to be resolved. The other matters have resolved, and frankly, he has a significant sentence that he's under. My recollection is I think his earliest release date is sometime in 2028 or 2029. I think the recommendation here is appropriate given what the plea entered here was. Also just taking into account his circumstances, that he has a significant sentence that he's already under. He's in MDOC and already working through the programming there. I think that the sentence makes sense given those factors. Thank you.
Thank you. Mr. Ray, was there anything that you wanted to say today?
I just wanted to apologize to the court for my actions. I know I was wrong, and I'm trying to get help from my drug use and starting to get back on the right track.
All right, thank you. Mr. Ray, I did have a chance to review the report in this case. I'm familiar with what happened in this circumstance that brings you before the court. I'm also familiar with your circumstances and background based on the information contained within that report. You know, given your history, it's clear to me that you do have a substance abuse problem that's been ongoing for a long period of time. You know, you've had various degrees of success at dealing with that. I think that's been compounded by some underlying mental health issues, which have also contributed both to your drug use and your criminal history. Given all of that, looking at the amounts involved in this case, which, you know, it's not the highest amount that I've ever seen, of course, but it certainly is a significant amount. It's an amount over and above what I would consider personal use. So I think there's definitely indications of trafficking here. And I think that the recommendation, particularly in light of your current sentence and current outdate, is appropriate. I think it addresses your conduct in this case and your history. So the court is going to follow that recommendation. The court is going to sentence you to 3 years, 4 months to 30 years in the Michigan Department of Corrections. You do have credit for 180 days served. That sentence to be served concurrent to any sentence you are currently serving. A crime victim's assessment in the amount of $130, court costs in the amount of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence, Mr. Ray. If you haven't already received it, you will be provided with a copy of some paperwork that explains to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with that appeal. If you haven't received those documents, your time for seeking an appeal will start running once you have received them. Do you have any questions, Mr. Ray, at all?
Your Honor, I do not.
Mr. Trush or Mr. Roll, anything further?
People, thank you, Judge.
Nothing further.
All right, thank you, Mr. Ray. Good luck to you going forward, and we're going to disconnect at this time.
Okay, thank you, Your Honor.
Your Alderman, are you ready on Mr. Ingersoll's case? I know that we had an issue with how we're going to proceed today.
Which one?
Well, that's.
Are you ready to go on the record in that file, though?
Yeah, we can go on the record. So I'm not sure, has he been connected via Zoom?
5-7.
Not yet.
Okay.
Let's go on record now. We have 3 files up for a sentencing hearing today: 236-657, 246-704, and 246-705. If I could have counsel for your appearances.
Thank you, Your Honor. For the record, my home back.
Your Honor, co-defendants, co-counsel for defendant Mr. Ingersoll, Zachary Hall, 7327.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Ingersoll as well.
Okay, so I know we written Mr. Ingersoll for a personal appearance here in court today. My understanding is that due to his status, that Roscommon didn't allow him to be transported. Is that right?
Well, Judge, I don't know much Roscommon, and I can leave defense counsel to speak to it. I think the issue had more to do with the fact that there's a federal and that was the concern that got raised. So we tried to have this go from a in-person hearing today to a live video.
Okay, is that right, counsel? I mean, is
Yes, that's exactly. I didn't know anything until I got a call from my client. My phone calls uncovered the same thing. There was the federal, I think, marshal in custody took issue with the writ that was sent. He requested that a new writ be sent, but that happened this morning.
all right. So are we going to proceed with sentencing by video if they connect, or do we need to reset this for an in-person hearing with writ?
Your Honor, I would leave it up to the court and.
Well, that's
maybe
it's not really up to me. It's Mr. Ingersoll's right, and he wasn't willing at the last hearing to waive his right to an in-person hearing. So
I think he would prefer Mr. Trush also talk to him to be here in person.
So,
for sentencing.
so I think that his preference is to be here in person. I do think there is a consideration for him of he wants to get under sentence. And there's obvious reasons I think why that is. So if he connects, I would prefer to put the question directly to him if he would like to proceed in that manner or delay it. Because again, I know that he's expressed to me that he wants he wants to basically get to federal prison as fast as possible. And that's where we all know this ends.
All right. So they haven't connected yet. I mean, we are 2 minutes ahead at this point, so
Would the court like me to call the Roscommon jail?
yeah. Let's take about a 5-minute break and we'll see if we can get.
All right.
Yeah, I do not see, press comment connected, were you able to contact them, Mr. Drew?
I was told in no uncertain terms that they're not doing anything without federal approval.
So we need to reschedule.
Yes, I believe so.
All right, Mr. Hallman, would you agree?
Yes, I would agree, Your Honor. Thank you.
All right, so the court will reset this for another sentencing hearing. I guess I'm gonna leave it up to the attorneys. Of course, I'm willing to sign whatever order needs to be signed for the federal government to approve this transfer here. So I'm not sure what that's gonna require, but just so council's aware. Certainly willing to do that, so I'm gonna leave that to council to find out what needs to be put in writing for that.
Understood.
Okay, Mr. Roll, anything further from your side today?
No, Judge, I think the record's sufficient.
Mr. Truce or Mr. Hallman?
Don't think there's anything I can add that would be useful.
Same, yeah.
Okay. All right, thank you. That's all for that hearing today. Our next hearing set for 10:15, so we'll go on the record at On the record in People versus Landon Edwards. This is case number 226434. The record should reflect Mr. Edwards is present here in the courtroom today. Counsel for your
Thank you, Your Honor. For the record, my phone did not speak.
Thank you, Your Honor. On behalf of Mr. Edwards.
And I did receive a couple character reference letters on behalf of Mr. Edwards. I did have a chance to review those prior to the hearing today. Mr. Edwards, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Trush about that? Yes, sir. Mr. Trush, are there any additions, deletions, or corrections that need to be made to that report?
So, Your Honor, I guess there's just one. There's just one correction I would make, or I would ask the court to make, and that's on page 2. So CFJ 284, page 2. The third paragraph from the bottom starts with consent was given to search the vehicle, ends with approximately 2.8 pounds of marijuana. I would ask that that be changed to reflect 2.8 pounds of suspected marijuana. It appears that only 55 grams of it was actually tested and confirmed to be marijuana.
People would object to that correction. As Mr. Trush is aware, the crime lab doesn't test all the marijuana, it takes samples from the group of marijuana. And if where the lab person had to have come here and testify, were they asked the question whether or not, in their opinion, all of these substances were marijuana, the response would have been in the affirmative, not just based upon their specific chemical testing, but also upon their observations of the suspected and now confirmed controlled substance THC.
All right. The court has, I mean, this isn't a scoring challenge, so there isn't an evidentiary standard that the court would apply, I guess, to a finding here. It's my view based on the testimony in the trial. I mean, I think I'm satisfied that the entire amount of the substance is marijuana, so I'm not going to change that. I think it's a correct statement. So, in light of all the evidence that was presented in this case, so I'll deny that request. Are there any other requests for changes?
No, Your Honor.
Okay. Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do people have any additions, deletions, or corrections?
The only addition, Judge, would actually be as to what the court's going to do for sentencing. The firearm involved is required to be confiscated and pursuant to MCL 752. And marijuana would be forfeited under MCL 333-7521 at 7.
Mr. Trush, any challenges to those?
I think statutorily the forfeitures have to happen.
Okay. Thank you. Any challenges to the scoring, Mr. Rolla?
No, Your Honor.
Anything on behalf of the people for allocation?
Judge, this is the defendant's second, third, and fourth felonies. We have a situation here where he has numerous prior weapons and controlled substance and alcohol offenses. He intended to sell the marijuana he allegedly grew under the MMMA dispensaries in Mount Pleasant. But after he was unsuccessful in doing so, the vehicle was stopped in Otsego County with over 2.5 pounds of marijuana. It's a situation where the recommendation in this case, guidelines are as to count 1, 2 to 17, one's up to 8 years. There's a recommendation of 2 to 8, and as to the CCW charge, it's 5 months to 28 months up to 7.5. The recommendation again 2 to 7.5, as well as circumstance already described regarding the firearm. The recommendation is appropriate. We think it should be followed.
All right, thank you, Mr. Trush.
Thank you, Your Honor. The situation here, obviously, this went to a trial. The matters were decided by a jury. The things that I would identify to the court here is really this changing landscape of the laws. And I mean that in the sense of, in the last 10 years, we've seen a dramatic shift in how marijuana is viewed. I think that directly pertains to this case. And I mean that in the sense of, in recent history, we've seen marijuana move from something that had no recognized medical purposes to something that had recognized medical purposes to something that's been decriminalized recreationally to now something that even federally is looking at being rescheduled, or I should say descheduled. So I say that in the sense of I don't think, at least there appears to be a huge discrepancy or contest as to what was going on here. It appears to me that there was a significant amount of marijuana. It's not uncommon, and we've seen these situations before where someone's looking at potentially selling overages or marijuana that they've grown legally under the Marijuana Act. It certainly is not, that doesn't make it legal, but it's also something that we've seen. It's a changing landscape, which does have some gray areas to it. I think that it would be appropriate for the court to be on the lower end of the guidelines here, given that this is, represents his second felony. So not a huge criminal history in that regard, but also just the nature of the offense in regards to marijuana and the changing landscape, what the marijuana laws look like. Additionally, in regards to the firearm, there's no suggestion that anything dangerous was being done with the firearm. It was being transported improperly. Again, it appears to me that he acknowledged, it appears that he had it in the car, forgot to take it out. It wasn't being transported properly. That's the crux of the crime here. It's not as if he was doing something overtly dangerous with the weapon. In that regard, I would suggest to the court, again, I think the lower end of the guidelines here is appropriate, and especially in light of the harsh penalty that's going to be imposed, as the court has to impose a mandatory consecutive 2-year sentence for the felony firearm, which again, doesn't contain any overtly dangerous act. I mean, it ties the court's hands in the sense that the court can't really look at what's going on. What's underlying happening, the court's just mandated to do a consecutive 2-year sentence to anything else it imposes. So my request would be for the court to really look at the facts and circumstances here and really look at what, if any, danger is actually being presented. And I would request the court to consider the low end of the guidelines here. Thank you.
Mr. Edwards, anything that you wanted to say?
No, sir, not at this time.
I did review the report. That gave me a lot of information about your background and your circumstances. I presided over the trial, so I heard the evidence and I'm familiar with the circumstances of the crime here today. I guess, a couple things I would say. Yes, there's a changing landscape, I guess, in terms of marijuana legislation and what's become legal over the last 5 to 10 years. I think what isn't in question is that it's still highly regulated, even though it's legal. And, if I like to homebrew beer and I made way too much beer, and I can't just take my overages and go out and sell it on the street to people, right? It's regulated. Everybody knows that. If you're involved in marijuana use or growing it, you either know or should know that there's regulations that you can't just take your overages and sell them. So the fact that it's newly legal or that there's an evolving landscape, to me, is not in any way an excuse. Everybody knows it's regulated, just like everybody knows alcohol is regulated. You can't just go out and sell it anytime you want under any circumstances. And if you're unsure about what the rules are, then it's up to you to find out what those rules are before you do it. I don't think there's any question that the amount of marijuana here indicates trafficking. The weapon issue, I guess, if you believe that it was just forgotten and left in the car, then it's easy to dismiss that as a mistake. What I think is more likely is that that weapon was there to protect you and your 2.8 pounds of marijuana that you were transporting and eventually going to sell. Which means that while it wasn't used in a dangerous way at the time, it certainly posed the potential to be used in a dangerous way, harmful either to yourself or someone else. So I don't find that there's really any real mitigating circumstances here based on the evidence. And I think the penalties are appropriate and the recommendations are appropriate. With regard to count 3, the felony firearm, the court has ordered that serve 24 months in the Michigan Department of Corrections with credit for 35 days served. With regard to the carrying a concealed weapon charge, court finds that 28 months to 7 years, Michigan Department of Corrections. Again, on that charge, you have credit for 0 days served. With regard to the controlled substance offense, 12 months in the Otsego County Jail, you do have credit for 30. Ms. Davis, is there correct jail credit on the marijuana charge?
Sorry, Your Honor. I think it's supposed to be 0. It says 0 on VIR.
If I may, I mean, I think the felony firearm has to be consecutive to the predicate offense, which means he wouldn't be entitled to credit on the CCW charge, but I think he would be entitled to credit on any other counts.
Ms. Davis or Mr. Rolla on that issue?
As far as credit as to the marijuana charge?
Correct.
The PSI indicated there's 0 credit on it. Am I reading something wrong?
Mine doesn't say either way on the marijuana
Well,
charge.
I've had it calculated 0 jail credit, mandatory 2 years, so it's gonna start consecutive to that, so it's gonna be 0 jail credit going towards the 2 years.
Okay, so the only one that he would get credit on is the felony firearm.
Correct.
Mr. Trush, I mean, that's what I'm getting from the department. I don't have any reason to doubt Ms. Davis. If that's incorrect, then that would need to be the subject of the post-sentencing motion to correct the jail credit as the count.
So, yeah, I mean, Your Honor, I guess I would just indicate, I would fundamentally disagree with that. However, I would indicate, given the circumstances, it seems unlikely to matter, given what the sentence is.
Okay, and I'm not saying you aren't correct. I'm just saying I think the way to decide that would be by motion. So the court is going to allow 0 days for credit as the count 1. All right, and as to count 1, also a crime victim's assessment of $130, court cost of $325, and $68 state cost, along with forfeiture of the substance that was confiscated. As to count 2, concealed weapons charge, $68 state cost, and as to count 3, felony firearm, $68 state cost. Mr. Edwards, you do have the ability to seek an appeal of the sentence, and Mr. Trush is going to provide you with acknowledgement of appellate rights. Have you done that, Mr. Trush?
We've actually already acknowledged him, and he's already submitted the paperwork for an appeal.
All right, thank you, Mr. Edwards. You are remanded.
Judge, one thing, I may have misheard the court, my fault. The sentence as to count 2, you said 28 months to 7.5 years, correct? Because that's what I believe it's supposed to be. I thought 5 or 8 years. I may have misheard that.
28 months to 7 years, 6 months.
Very good, thank you, Judge. That's
So
what
I may have misspoken. I may have only said 7.
Is it concurrent or consecutive?
So the counts 1 and 2 are consecutive to count 3.
Thank you.
Felony firearm would serve first. Mr. Rolla, anything else that we need to address?
No, Your Honor, thank you.
Mr. Trush.
I do just want to make sure there's a clear record for appellate purposes. Specifically, we are objecting to no credit being given to count 1, the marijuana charge. Our specific objection would be that the felony firearm is only consecutive to the predicate felony for the felony firearm.
Okay, thank you. Mr. Brown, are you ready with Mr. Munzel's case?
Yes.
People versus Scott Munzel, case number 246678.
Dr. Joanna Michael,
Very proud on behalf of Mr. Munsell.
This is the date and time set for sentencing in this case. Counsel present.
He is not. I did receive, I can put this on record now if you're on a play.
This was set for hearing at 10:30. It's now 10:35. Mr. Brown, go ahead, please.
Your Honor, I did receive a call from Mr. Munsell this morning at about 9:15. He did advise me that he was coming from Rapid City. When he went out to start his car, it would not start. And he called around and could not find a right to works.
Mr. Rolla, do people have any objection to issuing a bench warrant for Mr. Munsell's arrest?
I think it's appropriate. I've been here before, and persons come up with suddenly car failures on the day they're supposed to be sentenced.
Okay, so the court will sign that bench warrant. The court will order that Mr. Munsell's bond be revoked. Once he's arrested, he'll be held in the Otsego County Jail until the court can set this for sentencing. I do want to note for the record that the court did receive late Friday a victim's impact statement that I have attached to the PSI, but I just wanted people to be aware I didn't receive that. Haven't had a chance to review it.
Very good, thank you, Judge.
We're early on the next case. Mr. Brown, are you ready to proceed on that, or do you need time?
I have to see here. Yes, sir.
If you want to come right up to the podium there, we'll go on the record. This is People versus Ryan O'Neill. Suarez, case number 246700. The record should reflect what's present here in the courtroom today. This is the date and time set for sentencing. Executive counsel for your appearances on.
Larry Brown on behalf of Mr. Munsell.
And Mr. Brown, I know you have a challenge to the scoring of the guidelines, but before we get to that, Mr. Nagus, have you had a chance to go through the pre-sentence report or talk to Mr. Brown about that?
Yeah, well, he sent it to me. I was able to go through it and check it out. I did message him back that, I got everything was good.
Okay,
So,
do you need to speak with them before we proceed this morning?
yeah, if I can have a minute, I'll do it.
Yes. Yep. It's 10:38. We'll come back on the record at 10:45. Brown, again, before we get to the challenge, is there any additions, deletions, or corrections?
One minor one, Your Honor. I have it on page 6 under substance use and treatment. He is stating, right now it lists that he started using cocaine in 2009. Maybe that's a typo. He informed me that should be 2019, which we seem to comport with some of the cases involved.
Any objection to that change, Mr. Rowland?
No, Judge.
Court will order that that correction be made. Any other additions, deletions, or corrections?
No, Your Honor.
And any challenges to the scoring of the guidelines?
I just go on filed.
And that challenges to OB1, is that right?
It is, and I'm going through it, and I see I made an error where I think I mentioned it as OB5 in that first paragraph. That's
Anything you wanted to state for the record in support of that argument?
I think it's a simple argument. I don't think there's any evidence to support that there was an aggravated use of this weapon. He never displayed it or even implied it.
Thank you, Mr. Rowland.
The judge is not being charged as an aggravated use, as it's not a situation that he's accused of attacking anybody, but it's a weapon that was possessed. And clearly a weapon was possessed.
Again, Your Honor, this is being scored at 0 is that includes possession of a weapon. However, this is an aggravated use. Mere possession, to consider that an aggravated use, we're going to abrogate ever scoring 0 points.
I don't want to interrupt the court, Judge, but the statute's indicating that if it was possessed, it's one amount, 5 points. If it's used in a manner, then you have higher points. Now, I can understand defense argument where they say it was scored for 10 points or more because the weapon was actually used. This is only for only possession. I think 5 points is correct under OB1, under the statute.
All right, so here's how I view OB1. It's, under the statute, it's titled aggravated use of a weapon. Maybe I'm missing it, but Mr. Rowland, can you tell me where points are scoreable for mere possession?
I don't. Because under the statute, it excludes certain types of, unless the plea is to, under the directions. And again, I don't see that our office even got a copy of the objection. I can take a probation folder, not either. Otherwise, I'd have been a little more prepared and giving the response. If you look, I believe it's 7774.
Your Honor, I actually did receive.
Knowingly.
I'm sorry, just for the record, I did receive a response from the court and Ms. Streblow that they did receive this objection on May 10th.
Okay.
This, I wonder if there will be. It's 777.4 statute.
Okay, all right, so I just found what I think is controlling here. The court is gonna deny the challenge to OB one. Under People versus Brooks, and this is a direct quote. The fact that some kind of weapon is present by sight or by implication warrants the assessment of 5 points. So in my view, that case law interprets OB one to allow scoring of 5 points when a weapon is present, but is not either directly or by implication, a victim isn't made to believe it will be used. So, yeah, in my view, People v. Brooks allows the scoring of 1 point or 5 points under OB one under the circumstances present here. So the court will add that challenge, but the record's been made of that. Any other challenges, Mr. Brown?
No, Your Honor. And just for the record, that did not change the guidelines.
Okay, would not have changed.
Would not have changed that.
All right, thank you. Mr. Rolla, do the people have any additions, deletions, or corrections?
The only addition, Your Honor, we have is that, again, as a sentencing situation pursuant to statute, metallic knuckles have to be confiscated and condemned.
Thank you. Any challenges to the scoring of the guidelines? Anything on behalf of the people for allocation?
Judge, it's a first felony, but it is a second weapons offense. The guidelines are 0 to 9. There's a recommendation of jail with 2 days credit. We believe jail situation up to the court.
Mr. Brown, anything on behalf of your client?
Your Honor, I did see that Mr. Matos had a prior weapons offense. It was a misdemeanor. I don't think there's any violent offenses using weapons or anything else like that for that matter on his record. He's currently been married. His wife is here to support him. He's married for 4 years. They have a 2-year-old son together, a 14-year-old stepdaughter. He's not using substances. He did in the past. He's not at this time. He has very steady employment working in Spring Power Sports. I believe he's been working there for the past 3 years or so. So he has a lot of things going in his favor. I think that he at one point stated that he used some of these things for work. And even if he did have them for protection, I know there was something in the PSI about why anybody would need protection in this community. And this court sees a lot of things where people would need protection. And this is not a firearm. This was a set of metallic knuckles. And in addition to that, I'm sure the court is well aware of the childhood that he had, which at 10 years old, when you are told that your father was shot in the head and killed during a robbery, that undoubtedly had some kind of an effect, even if he doesn't realize it throughout his life. But he's 33, 34 years old right now. This was a bad decision on his part. I think he's going to learn from this. Out on bond, he's had no violations, no issues, no problems. So I would ask the court to take those things into consideration. I don't think incarceration is going to be a proper remedy here. He's got another 18 months that he is going to be overseen on probation. And that's not an easy thing to do either sometimes. So for him, I believe it might not be as difficult because I don't think he's going to mess up like that again. This was a good lesson for him.
All right, thank you. Is there anything you wanted to say today?
That's good. I agree with what he said.
I did read through the report. I'm familiar with the circumstances here. as Mr. Brown indicated, there's also information in the report about your background and circumstances. And so I take all of that into consideration. It does concern me that you were carrying this weapon, that it's clearly not a legal weapon to carry in the way that you were carrying it. I get wanting to have some kind of protection for whatever reason, whether it's what's happened in your past or just concerns about personal safety. There's a right way to do that and there's a wrong way to do that. And you've already kind of been down this road before, which concerns me. You had a previous conviction in Pennsylvania. Similar type of charge, different kind of weapon. And so when you had an opportunity to learn through that experience, if I'm going to carry a weapon, I need to have a permit and carry a weapon that's allowed under a permit for self-defense. And that didn't apparently sink in the first time. And so the court thinks that in that case, all you got was some probation and fines, costs, and restitution. In this case, I think a short jail sentence is necessary because you need to understand if you're going to keep engaging in the same conduct, illegal conduct, that each time you do that, there's going to be an increased penalty because it tells the court that you're not learning from the prior experiences. So I think the probation is absolutely appropriate in this case to provide some supervision over the next 18 months to make sure that you're doing the things that you need to do and staying out of trouble. And the court is also going to impose 30 days in the Otsego County Jail. You have credit for 2 days served. Again, I find that that's necessary both as a punishment in this case and hopefully as a deterrent to you going forward so that you understand if you continue to carry weapons that you're not supposed to have, that there's going to be a consequence of that. The court is going to adopt as the conditions of the probation all the terms and conditions in the report. The court is going to order $130 in crime victims assessment, supervision fee of $30 per month while you're on probation, court costs of $325, attorney fees of $350, a DNA testing fee of $60 and $68 state costs. The court is going to order forfeiture of weapon. Because you are currently employed, the court doesn't have any objection to your release to work camp. So during the time that you would otherwise be in jail, as long as you qualify for the work camp program, you'll be able to continue your employment while serving your jail term. Mr. Brown, if you can provide the appellate rights to Mr. Matos, please.
Yes, sign that acknowledgement. I'm tendering that to the court, Your Honor.
Mr. Roll, anything further today?
Thank you.
Mr. Brown.
No, Your Honor, thank you.
Brown, are you ready on Mr. Murphy?
Yes, Your Honor.
We're on the record in People versus Brian Murphy. This is case number 246706. The record should reflect Mr. Murphy's present here in the courtroom today. Thank you. That comes with this is the date time set for sentencing. Mr. Murphy, have you had a chance to go through the pre-sentence report and talk to Mr. Brown about that? Yes, sir. Brown, are there any additions, deletions, or corrections to that report?
Just one, it's a minor one. Under the victim's impact statement, it says defendant's description of offense. Based on the language, that should probably be the agent's description.
that, Mr. Rolla, it does read police report restoration, and it does.
There's no objection.
The court will order that we move to description of offense. Any other changes?
No, Your Honor.
There any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor, thank you.
Any challenges to the guidelines?
No, Judge.
Anything on behalf, do you have any victims that wish to address the court today?
No, Your Honor.
All right. Anything on behalf of the people for allocation?
Yes, thank you. This is a situation where the defendant stole from his employer. He was a cashier at Walmart, money out of the register. Concern is the fact that he had a prior January 13th, 1997 attempted embezzlement. Prior April 11th, 2012 larceny over 1,000, but less than 20,000. In this case, we've got the guidelines of 0 to 6 up to 5 years and recommendation of no jail. People think some jail should be imposed. If for no other reason that we should be going backwards as persons continue to repeat the same type of criminal behavior that got them in trouble in the past.
All right. Thank you, Mr. Brown.
Your Honor, given Mr. Murphy's age, he has a relatively limited criminal history here. Anytime he has been on probation or community supervision, he has been discharged successfully. While I do understand there is a prior larceny, this was back in 2011. This was, he was sentenced in 2012. This is over 10 years ago, 12 years ago or so. I'm not sure what is going on necessarily that prompted him to do this, but I believe that the recommendations here are appropriate, and I would ask the court to adopt a period of supervision, but not impose jail time.
Thank you. Mr. Murphy.
And there is restitution, $600. I don't know if that was mentioned.
Yes. Okay. Mr. Murphy, anything that you wanted to say? I did review the report. I'm familiar with the circumstances here as well as your past circumstances, Mr. Murphy. Number one, I think payment of restitution and probation is absolutely appropriate in this case. And I think there needs to be a period of time of supervision to make sure that you're complying with probation and that you're not committing any other crimes. I am going to extend the period of probation beyond what was recommended, I think more than here is necessary in this case. The court is going to place you on probation for a period of 18 months. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. I'm going to impose 90 days in the Otsego County Jail. The court is going to hold that time in abeyance. If you successfully complete your probation, then you won't have to serve that time. However, if you violate your probation in any way, the court can impose any or all of that time immediately. So there's going to be a significant consequence if you don't comply with the probation in this case. You do have credit for 1 day served. The court is going to order that you pay restitution of $600. That's to be paid to the Otsego County clerk to be dispersed to Gaylord Palmer. Crime victims assessment of $130. Supervision fee of $30 per month while you're on probation. Court costs of $325. Attorney fees of $350. DNA testing fee of $60 and a state cost of $68. You have the ability to seek an appeal of the sentence, and Mr. Brown is going to provide you with those appellate rights.
Yes, acknowledged receipt, Your Honor. I'm tendering that acknowledgement.
Ms. Davis, does he just need to contact Ms. Rose?
No, we're agent of legal.
So, Mr. Murphy, once you're contacted by a probation agent, make sure that you follow up with that contact, okay? Thank you, that's all for today.
All right, I believe that's my docket for the day.
Yes, we have one case left that's at 11:30. That's going to be resentencing by video. So we'll take a recess until 11:50.
All right.
All right, Mr. Hepburn, are you able to hear me okay?
Yes.
Okay.
You don't have a PSI for him, right? No. Okay.
We're just waiting for your attorney to sign on. She's in the process of doing that right now. Okay, it looks like we have counsel connected, so we'll go on the record. This is People versus Cody Scott Hepburn, case number 216245. We have Mr. Rolla here present in the courtroom on behalf of the people. And if I could have defense counsel put your appearance on, please.
Yes, Your Honor. I'm Janice Dager Margosian for Mr. Hepburn.
All right, and the record should reflect Mr. Hepburn is connected today by video from the Department of Corrections. The purpose of this hearing today, there was an error in the court's initial sentence in terms of what case this file needed to be run consecutive with. I did receive an email communication that indicates that the correct case is the 2015 Alpena case 156671. And Ms. Dager Margosian, I believe that counsel agrees that that is the correct case that should be run, that this should be consecutive to.
Yes, Judge, we agree that that's the one it should be consecutive to, and that everything else should be concurrent. And I'd ask Mr. Hepburn to address the court when the court wishes, if he has anything additional.
Okay, Mr. Hepburn, was there anything further you wanted to say on that issue?
Consecutive to the 156671 and concurrent to the 21-1366. That's all I'm concerned about.
Okay, and I believe that's correct. Mr. Rolla, would you agree?
I agree, Your Honor. I believe it should indicate a consecutive to Alpena case 156671, but concurrent with Alpena case 21-1366, which was originally indicated in the judgment sentence as to be running consecutive to.
Okay, thank you. Ms. Dager Margosian, anything else that we need to address? The court will issue an amended judgment of sentence that reflects that correction.
I think that's fine, Judge, and also to note that this satisfies the Court of Appeals requirement that we have a hearing and or resentencing, which we're having here to address any remaining issues.
Mr. Rolla, anything further for the record?
No, Your Honor, thank you.
Mr. Hepburn, any questions at all?
No, Your Honor, thank you.
Okay, thank you. That's all for today. That also concludes the court's morning docket. The court will be in recess until 1:30.
Thank you.